Councilmember Holland in the Pledge of Allegiance and the invocation, please.
I pledge allegiance to the
flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Please remain standing and bow your head as a sign of respect. To our military on duty here and overseas, please protect them, especially our naval personnel stationed in Afghanistan. Our firemen and policemen that guard the home front, please keep them safe. Our community, city, and business leaders, help them make good decisions. And special thoughts for the refugees around the world. May they soon find homes. Amen. Amen.
Thank you. All of our members of the council are here this evening. We have to ratify the accounts.
I'm going to recuse myself from this one.
For the accounts payable?
Yeah, we've got a payment to HDRS, our Beard and Associates on there. That's planned for.
Okay. All right. We're now on agenda 4, and that's the approval and ratification of expenditures. Vice Mayor Antoniak has recused himself. We have the accounts payable for June and July 2008. Are there any comments or questions on any of those? Councilmember Souza?
Mr. Mayor, I noticed in going through all the bills that we're buying water meters from 3 firms, and I thought that we had agreed a long time ago that when we purchase water meters, it would come from one firm. I would like a response from the water department relative to these 3 charges. One is from Dana Kepner Company for $56,195. Hernandez Company Incorporated, $8,164. And HD Supply Waterworks, $3,950. I know that you can't come up with an answer on that tonight, but I would respectfully ask you to maybe respond to the council.
Mr. Mayor, if I may, Mr. Sousa, I'd prefer if we got this answer in writing to the City Council so we can be in detail and correct.
All right, then you want a memo from me?
No, we'll do it just
all right.
based on this request.
Okay. Thank you. Very good.
Thank you.
Okay. Are you still willing to approve?
Oh, yeah.
Yeah.
Thank you.
Okay. Further?
I had
Councilmember
one
Osborne.
question. I was going to wait till the end, but I'll go ahead and ask it now, and I still would approve. My question was, there was a membership fee to GPEC for $21,000, and I'm not saying that's bad, but I don't know what that means for us. I don't know why we pay that, so I would love to hear some input. Thank you.
for different reasons.
You'd prefer to wait on that to answer that?
Yes.
Okay. All right. Could I have a motion to approve and ratify the accounts payable for June and July, please?
So moved.
Second.
I have a motion and a second. All those in favor signify by stating aye.
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 Opposed? Passes unanimously. Vice Mayor Antoniak is returning to the dais. We have no communications this evening. However, opportunity now for citizens to comment to the council, to express their view to the council on any subject that is not on this evening's agenda.
Mayor,
Anyone like?
Mayor, I have 2 speaker cards.
Okay. It sounds like we've got a third.
Okay.
Okay.
First speaker card is
okay.
Mary Greener.
Okay. And I would just proceed, we ask you to keep your comments to 3 minutes if possible.
Oh, it'll be under 3 minutes. Mayor and Council, my name is Mary Greener. I am a citizen of Goodyear and reside on Porter Lane. I am here before you today as a citizen of Goodyear, not as an employee. Yes, Patricia Miller is my sister. She is suffered enough, a name she took after an abusive relationship ended of 20 years. An email address she has used from many places, including my home, as she struggles as a single mother of 2 children and can't afford internet access or gas to get to the library. I've been her mountain through her struggles. And now she is mine. Yes, I have shared my knowledge of improprieties with her, and her desire to find answers is as strong as mine. Today I address you with a few issues. The answers to these questions are something I need to heal. From emotional abuse I was put through with my colleagues in the IT department at the City of Goodyear. Until I get these answers, I cannot heal. I will not stop. I will not walk away as my coworkers have and other employees of the city who have resigned. About 30 some odd of them. If Mary Greener goes, she has vowed not to leave quietly or without answers. If it takes me to hand out flyers door to door throughout the city to bring attention to the abuse and improprieties happening in this city, I will. I am a woman of integrity and honesty. I have been described by many as tenacious when it comes to finding answers. I will get answers. Here are a few of the questions I need answered. My recent public records request for information had records omitted and clearly indicated that steps are being taken by city management to circumvent open records laws. This needs to be addressed immediately. As a citizen, I am demanding to know where the backup tapes that were removed by the former IT director in June 2007 are. I have asked staff on several occasions with no response. These contained my personal information, my social security number, as well as my neighbors, vendors of the city, and other citizens. We live in the #1 state with regards to identity theft. If these tapes have not been destroyed, where are they to inspect? If they have been destroyed, have they been destroyed in accordance with state statutes? I have proof that mobbing has been occurring within the city, and it started within the IT department with the former IT director, who was selling the positions of infrastructure manager and applications and business manager to his buddies before he even ever opened a personnel file. I have proof the former interim IT director, as well as the finance department, were aware of and participated in buried rebates from computer vendors against state laws. I have proof the former interim IT director worked on his private consulting business during working hours at the city. I have proof the former interim IT director reduced his email database by 1/3 from 300 megabytes to 200 megabytes after a records request was received from the West Valley View for his emails last year. I witnessed the conversation with the former regarding what backup tapes to use for the request, as the former interim IT director wanted the current backup tapes used instead of the time period requested. There are many terminated, resigned employees that will agree the mobbing continued with the appointment of the current IT director. You have all been instructed not to talk to me, to funnel everything through the city attorney. Why? Why can't you talk to me? A citizen that you represent, about these issues that are not really related to my employment or my status. What is there to hide about the disposition of these tapes? If they were handled appropriately, my questions would have been answered long ago. I await your comments, actions, in response to these issues and the issues and questions in previous correspondence you received in my emails. Thank you.
Okay, Ms. Greener, thank you very much. You've made some serious allegations, obviously, and it's imperative that we respond to each one of those. There were several independent allegations here made. So, and it's certainly public now, so we'll have to respond in a public forum if we can
Thank
do
you.
that. Okay?
The second speaker card is Patricia Miller.
Excuse me. Mayor, Council, my name is Patricia Miller. I reside in Goodyear on Winsong Avenue. You may also know me as Suffered Enough. Regardless of what you have been told recently, the sources and uses spreadsheet is used to show a balanced budget and used to complete the forms required by law for the Auditor General of Arizona. It is also included in the budget book for the public. You can refer to the April 30th, 2000 council work session at 9 minutes and 19 seconds, where Finance Director himself states this: a $5 million loss noted in the general fund needs to be explained. Why is there not accountability by project in the CIP? It is my understanding that many projects have been overspent and bond monies may not have been used appropriately or as intended through the years ending June 30th, 2008. I am told by records request response that there are no detailed reports. Is this true? Does not the GASB principles apply to the Finance Department and the City of Goodyear? Do we not have periodic trial balances on accounts and funds? Do you know why the CIP in review is scheduled for September 22nd, 2008? Shouldn't this information be readily available now? Do we still need to clean up overspent fund balances? Is this going to cover the over expenditures of projects such as project number WA0401, noted as being funded last fiscal year and deferred to future years on the 5-year plan and currently overspent by my estimates? We sold $44.5 million in GO bonds for CIP in June 2008. Of that, $16.5 million was for water system improvements and $19 million for sewer. Why does the 5-year CIP only indicate one project on it, number WW0403, for $8 million, as being funded with bond revenue for 2008-2009? Where are the rest of the bond proceeds going? We are spending money before we have it and then issuing bonds? Is the money now going to be used for the infrastructure of the ballpark instead of its original purpose? Why are records requests not supplied in electronic format when they are available in electronic format? Answers to records requests are not fulfilled with current reports or records. Is this to intimidate citizens from questioning the actions of council and staff? Where did the backup tapes go that were removed from City Hall in 2007 from former IT director? These tapes contain personal information on every citizen of the city, including my social security number and of employees and citizens. The removal of these tapes has been questioned by IT employees and no answers have been supplied. Where are they? Have they been destroyed? If so, have they been destroyed in accordance with state record statutes? Why weren't the citizens of Goodyear and employees informed of their disposition? Why is mobbing of employees being allowed to continue within the city? Is our ethics committee aware of this? Is this a way to reduce the $5 million loss projected in the budget general fund? I have copies of my information requests as well as the responses I have received to date. If the public would like them, I will be more than happy to distribute these. I look forward to your responses to my open questions, both those posed here and in the unanswered correspondence you have previously received from me by email. Thank you.
Okay, we thank both of you for your comments this evening. Your comments will be noted in the minutes of the meeting, and we'll be able to respond to those, and we'll respond to those as soon as we possibly can. Staff will respond to you and the council and the public, and you'll be advised of the date of that response. It'll be as soon as we possibly can.
Thank you. That will be in public, the response?
Yes. Mr. Gelser, do you have any other? Mr. Gelser.
My name is Gary Gelser, Mayor and Council. I live in citizen of Goodyear. My comment concerns the recent action that the council took and the city manager advised concerning the ratification of payments. And if there is a new policy to be put forth that any inquiry of staff and the public, if there is an answer from staff, I think the answer should be dealt with in public. Sean Bradford, the Commissioner of Water, was ready to answer the question, yet the city manager directed him not to answer the question and to reply in writing to Councilman Souza and the rest of the city council. And I think that's wrong. If the answer is available at chambers, there are plenty of people who are watching online who want to know what's going on. And I think the answer should not be a written response to the 7 of you, but should be directed to the people so that the people can see it. Thank you very much.
Okay, certainly, Gary will take those comments into consideration in future meetings, and however, we'll proceed with the recommendation that was provided at this particular meeting tonight. Okay. Further comments from the public? Okay, thank you. We'll now move to the consent agenda, and consent agenda item 7H has been removed, and it will be brought before council on September 22nd. Okay, ask the city clerk to read consent items A through G and I through M by title only, please.
Item A, approved draft minutes of a work session held on July 7th, 2008, a regular meeting and a special meeting held on July 14th, 2008. Item B, approve a request from James Bellows representing Bellows Golf Holdings, LLC, for a transfer of a Series 7 liquor license number 07070250 from Streets of New York, Inc., DBA Taste Ultra Lounge, Scottsdale, located at 5910 East Shea Boulevard, Scottsdale, Arizona, to the subject property located at 15205 West Vineyard Avenue, Goodyear, Arizona. Item C, approve a request from Richard Teal representing GMRI, Inc., for a Series 12 liquor license number 120777700 for Red Lobster Restaurant located at 15333 West McDowell Road. Item D, approve the final plat for Pradera subdividing approximately 160.4 acres into 357 single-family lots and 114 court-home lots generally located at the northwest corner of Citrus Road and Lower Buckeye Road, subject to stipulations. Item E, approve the request for a use permit to allow a convenience use for a Walgreens drive-through pharmacy on a 1.67-acre parcel in the Mountain Ranch Marketplace at Estrella Commercial Center, a 21-acre commercial center generally located at the northwest corner of Estrella Parkway and Elliott Road, subject to stipulations. Item F, approve a 2-year extension of time to October 23, 2010, within which to submit the final planned area development plan for the preliminary pad zoning district at Estrella Commons, generally located at the southeast corner of Interstate 10 and Estrella Parkway. Item G, confirm the following 9 members of the community to serve on the Elected Officials Compensation and Retirement Benefits Advisory Committee: Scott Hoppe, Joanna Johannesson, Gwen LaMarche, Vincent Leotti, Heather O'Neill, Michael Sullivan, Tree Trin, Patricia Willoughby, and Jerry Wilson. Item H is postponed. Item I, authorize the city manager to execute a contract with Malcolm Kearney, Inc. in the amount of $809,241 to provide design and construction administration services for the Adam & Well Development Storage, Booster, and Pipeline Project. Item J, accept the dedication of right-of-way, water easement, sewer easement, public utility, and sidewalk easement, temporary drainage easements, and temporary drainage and turnaround easements associated with the improvements of the Amaranth development. Item K, accept the dedication of a public utility easement generally located adjacent to the Van Buren Street frontage of the Broadstone Canyon Trails development and 2 waterline easements located within the same development. Item L, authorize staff to enter into a contract with Ticketmaster to provide exclusive ticketing system services for the Goodyear Ballpark. Item M, adopt Resolution 08-1252 of the Mayor and Council of the City of Goodyear, Maricopa County, Arizona, authorizing the city manager or his designee to negotiate and execute new contracts and/or to execute assignments, assuming existing contracts with Project Design Consultants, Turner Construction, and Hayden Building Company to complete the design and construction of the infrastructure identified in the Infrastructure Development Agreement between the property owners and former developer of Ballpark Village Wood Corporate Campus, approved by council on May 29, 2007.
Okay, thank you. Would anyone in the public wish to remove an item from the consent agenda? Mr. Gelder.
And remove our ballpark design contract and have it presented by staff, please, so the citizens can know what's going on.
Mayor,
do
I
that
have
right
to
now.
recuse myself.
Oh, you got to recuse yourself.
Why don't we take
I'm going to take the others first.
Okay, we're going to have a conflict issue here, so would any other citizen wish to remove an item from the consent agenda? Okay, would anyone on council wish to remove an item?
I just have a question on F.
On M?
On F
F.
and Frank. I don't think I have to have it removed, but can I ask the question?
Yes, ma'am.
Say on F, yeah, they're delaying, they're getting a 2-year extension of time to construct that development. If there was a change in the overlay, and I don't know if there is going to be, Harvey, what would they come under? The original overlay or a new overlay? I'm sorry, guys, I'm giving you a hard time tonight, I know.
I apologize. Mayor, Council, could you repeat your question, please, so for clarification?
They're asking for a 2-year extension. They're not going to build for 2 more years.
Correct.
Okay. If there was an overlay change, if we did a different overlay on that area, would they have to abide by the new one or the old one? That's all I'm asking.
I would think it'd be the old one. They've already got.
I don't know the answer to that.
They've already got an approved PAD. That's what they're.
Yeah,
asking. Yeah, would
I
think
just
it'd be
need a
the
yes or no. I don't know. So that's why I'm asking the
It'd
question.
be the, Mayor, Councilmember Lord, it'd be under the original.
Under the original one. Okay. That's all I need to know. Thank you, Harvey.
Okay. Yes, Councilmember Souza.
Yes, Mr. Mayor. On item N, I was going to ask and read the following explanation for who's going to be paying for the cost of the infrastructure.
Well, okay.
I would hope, would that be the question that you're bringing up, sir? Relative who's paying the cost?
Yes.
Okay.
Yeah.
I think that
I just think there should be a public
I agree.
discussion of this.
Okay.
It should not be on the consent agenda, and that's why I asked it to be pulled. Feel free to ask any other questions you want about that item, sir.
I agree with you. I agree with him, the agreement that we made with him. I think it should, we've had 2 emails already. I'd like the city manager to say it publicly or
Yeah.
whomever, so that it's in our minutes.
All right.
Okay?
Well, we're going to get to that then.
Okay.
Any other items to be removed from the consent agenda?
Yes, Mayor, 7L, along with 7N.
7L?
And I'll have to recuse myself on both those items.
So, okay, you aren't saying you have a question on L, you're going to excuse yourself from
Right,
L.
on both
Okay,
L and M.
okay. Okay, then, seeing no other? All right, I'd like to have a motion and a second to approve consent items A through G and I through K.
Second.
I have a motion from Councilmember Souza and a second from Vice Mayor Antoniak. Roll call vote, please.
Vice Mayor Antoniak?
Aye.
Councilmember Sousa?
Aye.
Councilmember Cavalier?
Aye.
Councilmember Lord?
Aye.
Councilmember Holland?
Aye.
Councilmember Osborne?
Aye.
Mayor Kavanaugh?
Aye.
Passes 7-0.
Okay, well, now we're going to move to L and M, and Councilmember Souza Cavalier will remove himself from those items. Let's hold on a vote on L until we listen to M,
Yeah.
okay? So we have a citizen wishes to have a presentation on M. Okay.
Mr. Mayor, I'll go first, and then Sarah can add anything that she wants to, if that's all right.
Sure.
We have a prepared statement that we wanted to make just in case this came up. We have kept the council informed at every step along the way, so everyone is fully aware of what has been done. Although this has been covered in news articles and news releases posted on the city's webpage, city staff have been receiving questions about the status of the construction of the infrastructure improvements at the Goodyear Ballpark and Recreational Sports Complex. Therefore, we wanted to take the opportunity in open session to let the public know what's going on. The city had an agreement that called for the construction of certain infrastructure improvements. Under the terms of the agreement, the city was to contribute $10 million towards the costs of constructing the improvements. The developer and property owner were responsible for the remaining costs. The property owner provided provided the city a letter of credit to cover the costs of constructing the improvements not covered by the city's $10 million that came from the bond sale. The city and the property owners have been working together and continue to work together on this project. Nonetheless, circumstances arose that resulted in the city terminating the infrastructure agreement and assuming responsibility for the completion of the infrastructure. The city will be paying for the construction of them with the money remaining from its $10 million and the letter of credit that was provided by the property owners, and that money is today in the bank. Based on the information available to date, it appears that the city will have sufficient funds available to complete the infrastructure improvements that are planned originally in the infrastructure agreement. Be happy to answer any questions, or Sarah, if you have anything to add.
With city manager's statement, Mayor, council members. I think with the city manager's statement, he gave a good background of where we're at. We were provided financial security. We have funds remaining. The rest of the information is in a very detailed council action form. There's no contracts at this point to present to you because obviously it's a very fluid situation and we're moving very quickly. But what the city staff has been working on is assuming one existing contract with Turner Construction that's doing what we call the wet utilities out at the ball site, and using the contractors who have been on this project since the get-go, Turner Construction, Hayden Building Company, and the engineering firm PDC. So we wanted the authorization to negotiate and execute these contracts. We're working with the property owner in terms of the scope of the contracts at this point, so because it is their loan on their property that is provided the funds for this, so they're still in the mix. And the work's progressing. It's just who's controlling the process. But we're in no worse position. We're in the same position that we were prior to the termination of the infrastructure agreement, except we control the funds. And we're able to make sure that we're able to move forward and complete the infrastructure on time.
And we're in compliance with all the titles.
With respect to public procurement, when we first started this project, the Turner and Hayden were procured through Title 34 processes. So there's an argument that, you know, they can be doing this work under the existing procurement because it's similar. The procurement that we initiated was for infrastructure and utilities, and this is all falls within the scope. But to the extent that there was an argument that they didn't fall within that original procurement, there is a statutory provision that allows us to do an affidavit where it's impracticable to initiate a new procurement process. We have about 5 months within which to complete the remaining infrastructure, so timing is an issue for us. The procurement process would normally take about 2 months, so we didn't think we could start over. And the truth is we wouldn't change the team. We have completed infrastructure because of the way that the contractors construct roadways. They might do all of the grading at once, then they put all the curbs in. So there was issues about having a new contractor come in and whether we could get the warranties that we needed. There was, you know, and then the costs associated with having somebody else get up to speed on the project. So from a monetary standpoint, and from a continuity standpoint, and the fact that we've been very happy with the work that Turner and Hayden have done on this project, we thought we would keep the original 2 contractors on there, and PDC always, their contract falls outside the scope of the procurement process, so we're good that way. We did get the determination under the statute that is necessary if there were any question that Title 34 applied.
Okay, we'll get back to the public, but Councilmember Souza, did you want to read something to the public?
No, it's, I'm pretty much satisfied with the explanation the city manager has given us, and he's kept us very well posted on what has transpired, and this was brought to our attention. But I received several phone calls at home relative to this, and I felt that it should be brought as a matter of public so that they know that where these funds are coming from and that we're not spending money out of our budget.
Right.
And I think this paragraph where it falls under the fiscal impact, the city will be using the security provided by the property owner and the funds remaining from the city's contribution obligation, which is the $10 million that the city manager is talking about, would be used to complete the work covered by the contracts that will be executed. So that pretty much what explains it and satisfies it. And
Right.
I know the press has picked this up and it's been in the newspapers relative to what did transpire and how did this come about. So, but if they would pick it up again to make sure that the public understands that this is not an additional expenditure on behalf of the city, I'd appreciate that. Thank you, Mr. Mayor.
Okay. Further comments from the public? Okay. Comments from the council?
Yeah, I just think this is it's just a reminder to us sometimes that we need to be sure that we're bringing some of these things up, even though we've gone to the newspaper and they have published all this information. The fact that we're saying it in a council meeting so that it is in the council minutes. So thank you for coming up and doing this tonight. Thanks, Gary, for...
Vice Mayor Antoniak?
I do have a question. The public procurement, so we know it was all done according to Title 34. All the
Initial
public
procurement of Turner Construction and Hayden Building Company.
Were those guaranteed maximum price contracts, or what type of contracts were they?
I didn't negotiate those particular contracts. They were just procured under the construction management at risk umbrella of the procedures, but that doesn't mean there's a construction management at risk contract. There's all kinds of contracts that can fall within the scope of that.
Okay.
I think we had a guaranteed maximum price with the Turner contract.
Okay. Yep.
And the contracts that we're negotiating with Hayden Building Company will be guaranteed maximum price. We have a GMP already.
Okay.
Did you want to say something? Or?
No.
I saw you guys talking over there. I wasn't sure. So if one final question. In Hayden and Turner, stand-up contractors, I hope they don't take this as a question directed at them, but if they are to submit a bill to us in this time period, and we are to determine that it was work that was unnecessary in order to complete that project, who then becomes liable for that payment?
We're only picking up the scope that's relevant to this project. So our new contracts will pick up the work that we deem necessary, but we haven't seen anything that has been unnecessary from Turner and or Hayden. Both of them have been limited in terms of their work. They've been doing just the utility work. And we have our inspectors out there all the time. They have both been excellent to work with. Hayden Building Company has been very accommodating in terms of the payment situation. They've done excellent work. I've talked to the director of engineering, and he's very satisfied with the quality of work that they're doing. We haven't seen any overbilling. They've worked with us on value engineering. They've worked with us throughout this whole process.
With that, I think a thank you to Hayden and Turner during this time period as well is definitely in order and very much appreciated. I'm sure they're putting in a lot longer hours than they anticipated at this phase in the project.
Yes, they've shared some of the frustrations of this project with us.
Yeah. Do you want a motion for them?
Yeah, I'd like to get a motion to approve consent items L and M, please.
Mr. Mayor, I move that we approve consent items 7L and 7M as read by the clerk.
Second.
Motion from Vice Mayor Antoniak and a second from Councilmember Holland. Roll call, please.
Councilmember Sousa?
Aye.
Councilmember Lord?
Aye.
Councilmember Holland?
Aye.
Councilmember Osborne?
Aye.
Vice Mayor Antoniak?
Aye.
Mayor Kavanaugh?
Aye.
Passes 6-0.
Thank you. We'll now move to the business part of our agenda. We have 3 items on our agenda. The first one is fairly lengthy and includes ordinances to adjust the non-utility and utility development fees. We're going to start with Tracy DeSoma. She'll represent the staff, and then I'll ask for comments from the public. I would ask at that point the public comment on any one or all of the particular ordinances, if you would, and if you prefer to do it on each one, you still have that opportunity also. But, okay, so we'll start with Tracy.
Good evening, Mayor and members of the council. My name is Tracy DeSoma. I'm a contract analyst with the Budget and Research Division of the Finance Department.
Tracy, can you move closer to the microphone, please?
Sorry. Tonight I'm going to give you a little bit of background. In April 2007, Tischler Bice was awarded a contract in 2 phases to complete an EDU study and then a development impact fee study. In June 2007, the EDU study was completed and phase 2 of the impact fee study began. A draft report was presented to Council March of 2008. A modified report was presented to Council May 2008. In July of 2008, a public hearing was held. Tonight, staff is recommending that you adopt the proposed development fees with an implementation date of November 10, 2008. I do have some comparisons. Oh, there we go. Okay. We went through that really fast. First comparison, at fully implemented, the current fees would be $16,433. The new fees, proposed fees by the Tischler Bice report for north of the Gila River would be $14,850 for a single family resident. South of the Gila River would be $15,198.
What does fully implemented mean?
Fully implemented was the BBC report that was done December of 2006. We phased it in 4 phases.
Okay.
As of this time, we've phased in 2 phases. There's 2 to go. The next one would be October of 2008. The final one will be July of 2009. So fully implemented is a 16,433.
Thank you.
Here's comparisons to other cities around Goodyear. We're not the highest, we're certainly not the lowest, but we're well within the median range. This is a comparison that shows category by category what the fees change, and overall it's a 10% reduction from the fully implemented fee. And again, that's based on a single family dwelling unit. That was north and this is the south. It's a 12% reduction overall. That's it. Any questions?
How do we handle the multifamily before we proceed?
I do have that. It's not on the PowerPoint. Jeff, can you put up Elmo, please? Thank you. So this is based on a 300 multifamily project with 2 6-inch meters. Goodyear North would be a little over $2 million. Goodyear South just slightly higher than that, and again, we are within the median.
And Goodyear Current is fully implemented.
Correct.
We aren't near there right now in the second phase, as I recall. Are we?
We're in the second phase. There's 2 left.
I know. Do you know what it is?
I don't have that, but I can get it for you.
It's okay. All right. Is there an applicant? Is the Tischler Bice wishing to speak or no? No?
Mayor, I do have a speaker card,
Okay.
and I probably am going to...
Comments from the public?
My apologies if I pronounce the name wrong. Myra Irizarry? Oh, good.
Good evening, Mayor and Council. Thank you for the opportunity to speak this evening. I'm Myra Irizarry, and I represent the Home Builders Association of Central Arizona. And I appreciate working with staff throughout this process. It's been very interesting, and they've been very helpful in explaining the process to me. And we've gone back and forth a few times, and I certainly appreciate their patience. The association understands your need to continue with infrastructure and to adopt an increase in the impact fees. Although not fully implemented at this time at 100%, Currently, what the home builders are paying would be less than what you would implement in November. I did have a small handout passed out to each of you, which breaks down the fees of currently what the home builders pay, and then in November, what the north and south zone would be. The Home Builders Association really would like to request that you please consider options when you're adopting these fees. Two of the options were placed on here that we drew up. One would be to adopt the fees, but to implement them at a later date. In addition, to phase them in, similar to how you phased in the previous fees, even though we're at the second phase right now. So we just wanted to at least bring that to your attention and to ask that you at least consider those options based upon the current trend in the market, which, as we all know, is very, very bad. We do have companies of our membership that are on their third and fourth phase of layoffs. We have companies that are closing. And we have a lot of projects in different cities throughout the valley that are basically being walked away from. We're competing with resale market, we're competing with the foreclosures, and just not enough buyers. So we ask that you please consider options when adopting these fees this evening to just sort of help along the market at this time. Any questions?
We'll ask you questions as we proceed.
Okay,
That's
thank you.
okay. Further comments from the public? Okay, seeing none. Would the council like me to ask for your comments on all of these, or do you want to do each one individually? We're going to have to roll call each one of them individually, but would you like to make your comments at one time or on the?
Let's take it one time.
Okay.
I think it's.
All right, let's comment on one time, and Myra's here if you have any questions for her. Okay.
Oh, start with me? I'm thinking. Go ahead, Chris.
You know, it should be pointed out to the council, and I'm sure you observed this yourself, that of the 13 items that were presented to the council for review, that 5 of these have been reduced and 8 have been increased. And I'm sure that other municipalities have not done this. And I think that is direct negotiations with the Home Builders Association, I think. Is that correct?
Thank you, Councilman Sosa. We have been working with 2 other municipalities, one most recently Phoenix with their water resource fee, and they have agreed to implement it in phases. And it's actually the model, the very first option on your sheet that starts with holding it till January of 2010 and then phasing it in starting at 33% is what Phoenix has agreed to do. So that's kind of the examples we're looking at. And although we do very much appreciate that the impact fees that you would be adopting are less than what they would be at 100%. What we're looking at is what the home builder is currently paying now is not phased in at 100%, so it is indeed an increase for them.
My position is this, that in good times, the home builders have been reaching great profits, and now becomes a time when they're hurting a little bit. I think they have to use the profits that they earned in the past to cushion themselves at the present time to get over this, the dilemma that we're in. And that's my answer to it. I think we've been very open about this, and as we've been with the Home Builders Association down through my tenure in this council anyway. But that's where I stand on the issue.
We certainly appreciate your
Thank you.
opinion.
Councilmember Lord?
Myra, I appreciate you coming before us and giving us information and talking to us from time to time. But I think as a city, we've been terribly fair. When I look back, that December 6th is when we directed our staff to work with the development community and re-look at this. And I think we've had 2 studies, right? Did we kind of had 2 studies that we went through? Because we weren't believing one study, didn't we kind of redo a study? Or help me refresh my memory.
Mayor, Councilmember Lord, in December of 2006, the council acted and adopted the current set of impact fees, and the decision was made at that point to phase the fees in over four sections. They were 9 months apart, and as part of that, there was a lot of debate and some concern on this council. I wouldn't want to speak on your behalf, but on council's behalf, that we engage and we relook at the process. Staff immediately took that message home. We hired Tischler Bice, who is by far and away the standard bearer for impact fees in the Valley. I mean, they haven't done everyone, but they've done over 40, I think it was 44 communities in the Valley. We relooked at how our methodology was, and we looked at how we compare to other communities as we calculate our impact fees. We did a very, very thorough infrastructure improvement plan, which is the basis for the numbers that are before you tonight. And the reason why some of the fees have gone up and some of the fees have gone down is the result of the infrastructure improvement plan. We wanted to identify the infrastructure necessary, and I certainly can speak on behalf of the water resources fees, the infrastructure necessary to meet the projected demand. And that's going to change over time, but with an infrastructure improvement plan that we have in place, staff is very, very confident that we've met the requirements in the direction provided by council, which was develop a kind of a standard system and engage the development community and the home builders, and we feel that we've done both.
Well,
Does that answer your?
Yeah, thank you for
You're
regurgitating
welcome.
all of that. I
No.
appreciate it. I agree. I think the staff's done a great job, and I really appreciate the time you've taken with the developers and with the Home Builders Association to discuss all of this. I just feel that we're up here to protect the citizens and to be sure we have the infrastructure we need when people come into the city, and there are other financial mechanisms that the builders community or developers use to retrieve some of their funds. Is that not correct?
Mayor, Councilmember Lord, yes, I can't
Yes.
speak for the development community, but
Yes, I just want that to say, so that when you look at these fees, it doesn't mean there isn't some way, somewhere down, that they retrieve some of these streams through another financial situation, without going into details on what that is.
And if I may, Mayor, Councilmember Lord, it's important to note that the infrastructure improvement plan is the backstop, is the backbone for the infrastructure necessary. And if we were to entertain any ideas of phasing, certainly that's council's direction, there could be the possibility that infrastructure is necessary and there isn't a mechanism to fund those. And then that would be a question for this council and for city staff on how we would address that potential shortfall.
Yeah, I agree, and I don't want a shortfall. I think we had discussed that a long time ago, that was key. So under those circumstances, staff, thank you for working so hard on this. I appreciate it.
Okay, comments over here, Vice Mayor?
Yeah. First, I want to be clear. I'm inclined to adopt the ordinances as they will be read by the clerk here in the not so distant future, I'm sure. But I do have a bit different approach to the current economic conditions that I'd like us not necessarily to consider tonight, but would like staff to think about from my perspective that I've been reading about, and that is in places like Anaheim, California, and some other locations throughout the country, some other southwestern United States, they've put a flat moratorium on impact fees. I'm not saying that's a good thing, but I'm wondering if there's a phased approach, because this money is real money to these developers. And when we talk about $2.3 million marks or whatever was on the last slide for a multifamily housing complex or a large, retail development or a single house, we impact that. We take that impact fee and we say, okay, you're pulling your permit to build, pay us now. Right? So they pay us 100%. They slide a check for $2 million or for $15,000 or whatever it is for that single permit right then and there. And I don't know about the rest of the council, but I'd still like to see those permits coming across the desk such that when we rebound from this economic climate, which we will, just like everything, housing and development are cyclical, we're going to come back up. And I wouldn't want us to have a backlog like we had and we were experiencing back in, what was it, in 03, between 03 and 05, in my first couple of years here, we were talking, and all we heard from the development community was, we can't get a permit through the door. We can't get a permit through the door. We can't get a permit through the door. I don't want to be having that conversation 2 years from now. So what I'd like us to consider is perhaps a delay of that fee such that they put 50% across the desk at the time. This isn't your approach. This is totally different than the home builder's approach to the issue of phasing it in. This is saying, this is the fee that we anticipate. And at the time you pull that permit, that's the fee you're going to be charged. You may not build for 2 years from now. I'd like us to give some consideration to the fact that we collect that money and we sit on that money for a year, 2 years, Or perhaps in the case of the PAD this evening, we've now accepted a 2-year delay on a PAD during consent, and had they had permits pulled on that, we'd be sitting on their money for another 3 years. And so, given the value of money and the time associated with that money, I'd like us to be sensitive to that, and I'd like us to discuss opportunities such that we could phase that impact out over a time period, such that at the time of building permit, maybe it's 25% is due, or 50% is due, and at the time of grading, another 25% is due, and at the time of vertical construction, another 25% is due.
So you're not
I'd like us-
arguing the amounts.
I'm
You're
not
just
arguing the
saying
amounts.
the phase-in
I'm
of the
saying
money.
it's that phase. It's kind of like me going and buying a house. I put $1,000 across the table for earnest money, or for them to go for a builder. I put $1,000 down. They start building the house. At that time, they go and pull the permit. They get dinged, not dinged, but they get rightfully charged $15,000, or a commercial developer $1 million, depending on what it is. I'm saying spread that out. They're not going to realize the benefit of that dollar, of that $1 million, until later on in the phase.
Well,
Yes, we
they-
might have to build. We might have to build infrastructure, and that's part of this evaluation. But I'd at least like to know whether my colleagues would like to have that conversation. It's not one we're going to solve tonight, but it's one I've been reading about over the last couple
You made a statement
of
that you
weeks.
said we'd have to build the infrastructure, so you're
Well,
saying
I need to
we
understand the
build it
impacts.
without the money. Is that what you're saying?
Maybe, maybe not. I'd need to understand what the impacts are to us collecting less of a fee. We've got a lot of vacant houses right now, and we've got a lot of, a lot less toilets and a lot less water that's being flushed down the drain. Not that you're seeing the impact. Maybe you are, Sean, in your water facilities. But I'd like to have a dialogue and a true understanding of what does that impact mean over that time period, such that 24 months from now, on the upswing, if there's rather than having 10 permits ready to build, we've got 100 permits with people ready to build, and we've got an incentive for folks to keep designing, keep thinking about construction within the city of Goodyear, such that we're ready to go.
Let me just clarify that, and we would certainly need a legal interpretation of that, because that's a change in policy. But let me, these fees are paid when they pull the site permit, is that correct?
Mayor, they're pulled at time of building permit issuance.
Right, okay, and then for a multifamily, that could be a year. Or commercial, it could be a year. But for residential, it's about 4 months. And by this thought process, you'd be paying about not every month, but you'd be paying 4 times in the life of construction, which would seem to be certainly difficult for our staff.
It could be problematic.
It's an administrative issue.
It could be.
Mayor, Council. Also, in a lot of these large multifamily projects, they often don't pull one permit. It's usually a permit for each building, so there might be multiple permits. So oftentimes they'll phase it in, so it is incrementally done over a period of time, as well as commercial. It's not done all at once. Fees.
So an apartment complex that has 10 buildings or 12 buildings pulls one building at a time? They don't pull the whole set?
Sometimes they do, and sometimes they don't. Most, one of them has pulled they want all the permits at once. Some usually do it incrementally, because once we get a permit, we finalize it on a permit-by-permit basis, so we can finalize one building, but they may not be done with another building, so that gives them the flexibility to continue working on that building.
Okay, but flip it around. I guess if we had 100%, if somebody's making the determination of whether to pull a permit or not, and that impact fee, which I'm getting the sense from some of these other communities is making that decision from what you're reading in trade magazines and a variety of other places, like the Anaheim example, where they've just flat said, we're not taking impact fees on a certain water project or something. I'd rather see us have that building permit pulled and sit on half their money than not have the building permit pulled and never have the money in order to build the infrastructure for that. And then, we control C of O. We control a lot of things that happen after that, and can say, you're not going to get C of O, or you're not going to get, into this structure. You're not going to get access to. You're not going to turn on your water meter.
Well, let me ask for legal interpretation, because this is a change of policy. Can we do it? And then if it can be done, then every council member can state whether they want to support that or not.
And I don't know that it's tonight. I don't know that it's tonight, Mayor. I wanted to bring it up.
Well,
as an
these are
idea. I was
tonight,
reading-
though.
I don't
Yeah,
know if
no,
I have
I'm not
enough-
talking about changing it tonight.
Okay, because I don't have enough
We
information.
can come back. I'd like staff to look at what other cities are doing in
That
terms of
decision.
this exam.
Well, then you'd postpone it.
Yeah.
I don't
Is that what you want to do?
Well, I don't think
I don't think I do.
No.
Postpone this?
I made it very clear at the beginning, I'm going to
No,
vote
I
for
don't
the motion on the
understand
table. I don't want to delay this implementation. This implementation has to be done, but I'd like us to have a more comprehensive discussion about the timing of impact fees and the impacts that has on our economics and whether or not we're going to have a backlog
Those are
a
options.
couple of years down the road.
Those are options that we have. They would be presented back to us. We can
Right.
ask the staff
Right.
to do that.
Right.
Mayor, just one comment. You know, this is a subject that we have beat to death. I mean, it's not like it's just coming up and it's brand new. We have worked on this meeting after meeting, and all of us and with the staff. And so I feel like what's being presented is a good approach. However, it is good to hear what our options are from staff. We've gone to the phasing approach in the past, and that worked well. We could do that again. That needs to come from staff back to us, that these are some options that we could put in place to make this work for you. But I'm definitely for, let's do this and let's get going. We just beat it to death.
Yeah, I think you had misinterpreted me. I was talking about what Rob was talking about. I don't have enough information. I have enough information on this.
Oh, you have enough information to make a decision
Yes,
tonight?
yes. It was what Rob was talking about.
Then let's move on that decision.
Yeah.
Councilmember Cavalier, any comment?
No, I'm fine.
Okay. No further comment on any of the ordinances at this point. Okay, if you have one, certainly interrupt me as I proceed, because I'm going to be moving fast through these, okay? We'll do each one, we'll do a roll call vote. Ask clerk to read 08-1123 by title only.
Adopt ordinance 08-1123, amending paragraph H of section 9-8-3 of Article 9-8 of Chapter 9 of the Goodyear City Code to provide for the imposition of a general government development fee on all new residential and non-residential development to serve demand resulting from projected new development for the period 2007 through 2013, providing for an effective date and providing for separability.
Okay, last time, any further comment from the public on this ordinance or any other regarding impact fees? Seeing none. Any comment from this council? None. Okay.
Move the adoption of the ordinance.
Okay. Motion, please.
Move the adoption of the ordinance.
Okay.
Second.
I got a motion and a second. Roll call vote, please.
Councilmember Cavalier?
Aye.
Councilmember Lord?
Aye.
Councilmember Holland?
Aye.
Councilmember Osborne?
Aye.
Vice Mayor Antoniak? Councilmember Sousa?
Aye.
Mayor Kavanaugh?
Aye.
Passes 7-0.
Would you read ordinance 08-1124 by title only?
Adopt ordinance 08-1124, amending paragraph J of section 9-8-3 of Article 9-8 of Chapter 9 of the Goodyear City Code to provide for imposition of a library development fee on all new residential development to serve demand resulting from projected new development over the period 2007 through 2013, providing for an effective date and providing separability.
Can I have a motion, please?
We adopt ordinance 081124 as read by the city clerk.
Second.
Mr. Mayor, point of order. Is it necessary for the city clerk to read the total content?
Yes, it is. Yeah.
Yes.
We've asked that question.
You better get a couple more bottles of water.
Okay. Can I have a roll call vote, please?
Councilmember Lord?
Aye.
Councilmember Holland?
Aye.
Councilmember Osborne?
Aye.
Vice Mayor Antoniak?
Aye.
Councilmember Sousa?
Aye.
Councilmember Cavalier?
Aye.
Mayor Kavanaugh?
Aye.
Passes 7-0.
Okay, ordinance 08-1125.
Adopt ordinance 08-1125, amending paragraph G of section 9-8-3 of Article 9-8 of Chapter 9 of the Goodyear City Code to provide for the imposition of a public works development fee on all new residential and non-residential development to serve demand resulting from projected new development over the period 2007 through 2013, providing for an effective date and providing for separability.
Mr. Mayor, I move that we adopt ordinance number 2008-1125 as read by the clerk.
Roll call
Second.
vote, please. Councilmember Souza added second. Roll call vote, please.
Councilmember Holland?
Aye.
Councilmember Osborne?
Aye.
Vice Mayor Antoniak?
Aye.
Councilmember Sousa?
Aye.
Councilmember Cavalier?
Aye.
Councilmember Lord?
Aye.
Mayor Kavanaugh?
Aye.
Passes 7-0.
Okay, let's go with the Vice Mayor doing the motions and Councilmember Cavalier the seconds. Is that okay?
Great.
Good. Ordinance 08-1126.
Adopt ordinance 08-1126, amending paragraph E of section 9-8-3 of Article 9-8 of Chapter 9 of the Goodyear City Code to provide for imposition of a police development fee on all new residential and non-residential development to serve projected demand resulting from new development over the period 2007 through 2013, providing for an effective date and providing for separability.
I move that we adopt ordinance number 2008-1126 as read by the clerk.
Second?
Second.
Roll call vote.
Councilmember Osborne?
Aye.
Vice Mayor Antoniak?
Aye.
Councilmember Sousa?
Yes. Aye.
Councilmember Cavalier?
Aye.
Councilmember Lord?
Aye.
Councilmember Holland?
Aye.
Mayor Kavanaugh?
Aye.
Passes 7-0.
Ordinance 08-1127 by title only.
Adopt ordinance 08-1127, amending paragraph F of section 9-8-3 of Article 9-8 of Chapter 9 of the Goodyear City Code to provide for the imposition of a fire and emergency services development fee on all new residential and non-residential development to serve demand resulting from projected new development over the period 2006 through 2015, providing for an effective date and providing for separability.
Move that we adopt 2008-1127 as read by the clerk. Second.
Roll call vote.
Vice Mayor Antoniak?
Aye.
Councilmember Sousa?
Aye.
Councilmember Cavalier?
Aye.
Councilmember Lord?
Aye.
Councilmember Holland?
Aye.
Councilmember Osborne?
Aye.
Mayor Kavanaugh?
Aye.
Passes 7-0.
Ordinance 08-1128 by title only.
Adopt ordinance 08-1128, repealing paragraph I, N, O, and P, and creating a new paragraph I of section 9-8-3 of Article 9-8 of Chapter 9 of the Goodyear City Code to provide for the imposition of a Parks and Recreation development fee on all new residential development to serve demand resulting from projected new development over the period 2007 through 2013, providing for an effective date and providing for separability.
Move we adopt ordinance 2008-1128 as read by the clerk. Second.
Roll call.
Councilmember Sousa?
Aye.
Councilmember Cavalier?
Aye.
Councilmember Lord?
Aye.
Councilmember Holland?
Aye.
Councilmember Osborne?
Aye.
Vice Mayor Antoniak?
Aye.
Mayor Kavanaugh?
Aye.
Passes 7-0.
Ordinance 08-1129 by title only.
Adopt ordinance 08-1129, repealing paragraph D and L and creating a new paragraph D of section 9-8-3 of Article 9-8 of Chapter 9 of the Goodyear City Code to provide for the imposition of an arterial streets development fee on all new residential and non-residential development to serve demand resulting from projected new development over the period 2007 through 2013, providing for an effective date and providing for separability.
Move we adopt ordinance number 2008-1129 as read by the clerk. Second.
Councilmember Cavalier?
Aye.
Councilmember Lord?
Aye.
Councilmember Holland?
Aye.
Councilmember Osborne?
Aye.
Vice Mayor Antoniak?
Aye.
Councilmember Sousa?
Aye.
Mayor Kavanaugh?
Aye.
Passes 7-0.
Ordinance 08-1130 by title only.
Adopt ordinance 08-1130, amending paragraph M of section 9-8-3 of Article 9-8 of Chapter 9 of the Goodyear City Code to provide for the imposition of a regional transportation development fee on all new residential and non-residential development to serve demand resulting from projected new development over the period 2007 through 2013, providing for an effective date and providing for separability.
I move that we adopt ordinance number 2008-1130 as read by the clerk. Second.
Councilmember Lord?
Aye.
Councilmember Holland?
Aye.
Councilmember Osborne?
Aye.
Vice Mayor Antoniak?
Aye.
Councilmember Sousa?
Aye.
Councilmember Cavalier?
Aye.
Mayor Kavanaugh?
Aye.
Passes 7-0.
Ordinance 08-1131 by title only.
Adopt Ordinance 08-1131, amending Paragraph A of Section 9-8-3 of Article 9-8 of Chapter 9 of the Goodyear City Code to provide for the imposition of a water development fee on all new residential and non-residential development to serve demand resulting from projected new development over the period 2007 through 2013, providing for an effective date and providing for separability.
Move that we adopt Ordinance 2008-1131 as read by the clerk.
Second.
Councilmember Holland?
Aye.
Councilmember Osborne?
Aye.
Vice Mayor Antoniak?
Aye.
Councilmember Sousa?
Aye.
Councilmember Cavalier?
Aye.
Councilmember Lord?
Aye.
Mayor Kavanaugh?
Aye.
Passes 7-0.
Ask the clerk to read ordinance 08-1132 by title only.
Adopt Ordinance 08-1132, amending Paragraph C of Section 9-8-3 of Article 9-8 of Chapter 9 of the Goodyear City Code to provide for the imposition of a water resources development fee on all new residential and non-residential development to serve demand resulting from projected new development over the period 2007 through 2013, providing for an effective date and providing for separability.
Move we adopt Ordinance 2008-1132 as read by the clerk.
Second.
Councilmember Osborne?
Aye.
Vice Mayor Antoniak?
Aye.
Councilmember Sousa?
Aye.
Councilmember Cavalier?
Aye.
Councilmember Lord?
Aye.
Councilmember Holland?
Aye.
Mayor Kavanaugh?
Aye.
Passes 7-0.
Ordinance 08-1133 by title only.
Adopt Ordinance 08-1133, amending Paragraph K of Section 9-8-3 of Article 9-8 of Chapter 9 of the Goodyear City Code to provide for the imposition of a reclaimed water development fee on all new residential and non-residential development to serve demand resulting from projected development over the period 2007 through 2013, providing for an effective date and providing for separability.
Move we adopt Ordinance 2008-1133 as read by the clerk.
Second.
Vice Mayor Antoniak?
Aye.
Councilmember Sousa?
Aye.
Councilmember Cavalier?
Aye.
Councilmember Lord?
Aye.
Councilmember Holland?
Aye.
Councilmember Osborne?
Aye.
Mayor Kavanaugh?
Aye.
Passes 7-0.
Ordinance 08-1134.
Adopt Ordinance 08-1134, amending Paragraph B of Section 9-8-3 of Article 9-8 of Chapter 9 of the Goodyear City Code to provide for the imposition of a wastewater development fee on all new residential and non-residential development to serve demand resulting from projected new development over the period 2007 through 2013, providing for an effective date and providing for separability.
Move we adopt Ordinance number 2008-1134 as read by the clerk.
Second.
Councilmember Sousa?
Aye.
Councilmember Cavalier?
Aye.
Councilmember Lord?
Aye.
Councilmember Holland?
Aye.
Councilmember Osborne?
Aye.
Vice Mayor Antoniak?
Aye.
Mayor Kavanaugh?
Aye.
Passes 7-0.
Ordinance 08-1135 by title only.
Adopt Ordinance 08-1135, repealing Section 9-8-4 of Article 9-8 of Chapter 9 of the Goodyear City Code and replacing it with a new Section 9-8-4 of Article 9-8 of Section 9 of the Goodyear City Code to provide for new, increased, or adjusted development fees, providing for an effective date and providing for separability.
Move we adopt Ordinance 2008-1135 as read by the clerk.
Second.
Councilmember Cavalier?
Aye.
Councilmember Lord?
Aye.
Councilmember Holland?
Aye.
Councilmember Osborne?
Aye.
Vice Mayor Antoniak?
Aye.
Councilmember Sousa?
Aye.
Mayor Kavanaugh?
Aye.
Passes 7-0.
Okay, this has been a monumental task, and the entire staff contributed to this, so we're thankful to you and appreciate your expertise in this one. Now consider granting authorization to initiate the annexation of 440 acres of land for development known as Terra Sante. Katie Wilkin.
That's not the correct. I need Elmo.
You're one ahead of him.
Thank you. Thank you, Mayor Kavanaugh, members of the council. Staff has received a request to annex 440 acres southwest of Rainbow Valley Road and Willis Road, northeast of Waterman Wash, which you can see here is the orange area. This large dotted line is the proposed State Route 303. The purpose of this annexation is to facilitate the development of a master plan community known as Terra Sante. Staff has also received a request to rezone 848 acres to the PED zoning district for the development known as Terrasante. 568 acres of this 848 acres are already within the city, which you can see is the northeast portion here. 200 acres are not within the city limits and need to be annexed before the rezoning can be considered. And that area is the southwest portion here. Of the 280 acres not within the city, 160 acres are owned by the New River Sod Company and 120 acres are owned by Stewart Title and Trust. These are the applicants of this annexation. Since the two owners are the applicants, this means that 2 out of 2 property owners are in favor of annexation, which meets both the 51% of assessed valuation and property owners tests. In 2000, Council adopted a 2-part process for annexation. The first part is to come to Council to review the annexation from a policy standpoint, which is what we're doing tonight. If staff receives authority to move forward with the annexation, we'll submit the blank petition and map to the county recorder and move forward with the annexation process. It is important to note that by giving staff authority to move forward with the annexation, it in no way obligates the city to annex the property. The property is currently zoned Rural 43 by Maricopa County. It is located within the city's municipal planning area and is contiguous to the city. There will be no county islands created by the annexation. Along with the rezone and annexation requests, we have also received a development agreement. I would like to go over some of the major items of the development agreement. The site will be served by Fire Station 184, which will be located approximately where this blue square is right here. The development agreement makes provisions for developer contributions for operation and maintenance costs. An exact figure hasn't been determined yet because the city staff is still formulating what that exact figure needs to be. The fire contribution will be equal to that of neighboring developments. Fire Station 184 will also include a police substation. The Terrasante development will require the need for a new police beat. To provide for this new beat, the applicant has made provisions for contributions to support operations and maintenance of the new police beat of $1,800,000, which will be broken down into 3 payments of $600,000, the first which will be due before issuance of the first building permit. There are currently no water services available to the site. Furthermore, the Integrated Water Master Plan found that the water quality in the area is not good quality. In order to provide water services to the area, the developer will need to construct a 30-inch potable water transmission line, which will bring water to the Rainbow Valley Water Supply Facility from northern Goodyear. And this transmission line was in the Integrated Water Master Plan. Prior to approval to any preliminary plats, the developer will fund a study to evaluate the capacity of an existing 16-inch line, which is currently within the area, to determine if the 30-inch line is needed. If it is necessary, the applicant will pay their pro rata share of the 30-inch line or construct the line themselves, and which will be subject to cost recovery. There are 2 types of water rights that the city needs to extract water. First, we have the wet water rights, which is the physical source of water. The second is the legal right to extract water. Oftentimes when developments come to the city, they already have enough legal rights to water to be able to provide for the proposed development. They convey those rights to the city, so the city has a legal right to extract the water that's there. Terrasante has plans to provide the wet water through the 30-inch transmission line, but they don't have enough legal water rights to provide water to the proposed 2,400 dwelling units in the Terrasante development. So before the approval of any final plat, the developer will need to fund the acquisition of water rights from other sources in order to serve the property adequately. Wastewater services will be served by the planned Pecos Road Wastewater Reclamation Facility. This facility has not been sited or funded. The applicant will be responsible to fund a wastewater facility study to define the location and size of the first phase of the Pecos Road facility. The study will be completed before preliminary plat approval. The applicant will be responsible to construct the first phase of Pecos Road facility subject to cost recovery. Finally, As you can see, the Loop 303 runs through the property, and the applicant has made proper provisions to reserve land for the Loop 303 right-of-way. Staff does recommend that council authorize staff to move forward with the annexation process. The representatives of the applicant are available for questions, and I'm available for any questions you may have. Thank you.
Okay, would the applicant wish to make any comment?
Mayor Jeff Bliley, 4800 North Scottsdale Road. I think Katie gave you a pretty good overview of the project. I'm here happy to answer any questions you might have. Thanks.
Okay, thank you. Comments from the public? Okay, could I have a motion then to approve the authorization to initiate the annexation?
Mr. Mayor, move the City Council authorize staff to initiate the annexation of 440 acres of land generally located southwest of Rainbow Valley Road and Willis Road for a development known as Terrasante.
Motion from Councilmember Souza and a second from Councilmember Cavalier. Comments, questions? Councilmember Cavalier?
Yes, I'm still concerned about this water issue because in the statement here it says that there's a 16-inch potable water line in the vicinity, water supply facility which may be adequate to serve the site. Is it or is it not?
I believe the city is not sure if it's able to fund the site, which is why the applicant's going to fund a study to determine if that 16-inch
The applicant's
line.
going to fund a study?
Yes,
Okay.
before, I believe, preliminary plat approval. So,
Through preliminary plat.
yeah, so we will study this issue, and the development agreement spells out if it's, option A, if the 16-inch line is enough, or option B, if it's not enough, then they'll have to construct the 30-inch line.
Okay, thank you. That-
Well, it sounds to me that this area, well, certainly in our planning area, and so I think the annexation will be fine, but it seems like there's an awful lot of homework and work to be done before it timely will be ready to develop. So that's my only comment.
Question on how are you going to gain the additional water rights? What are your options there?
Well, Mayor, we've been meeting with Sean and staff on this issue quite a few times, actually, over the past 3-4 months. We have some options. We have about 2,800 acre feet that we're bringing, but that's not enough for the project for the 100-year assured water supply. So we've talked about buying some CAP water or some CAGRW. I can't remember the acronym, but
Are you talking wet water? Or?
No, these are paper water.
That's what I thought. That's
Yeah.
what I'm asking.
Yeah, that's what we'll be buying.
The city's a member of the CAP, and we're also members of the CAGRD, which is the Central Arizona Groundwater Replenishment District, and we're also members of the Central Arizona Water Conservation District, CAWCD, lots of acronyms. As a member of these organizations, the city has ability to get excess or in lieu water that isn't being currently used, and what we can do is we can store those into storage facilities and then generate a credit, and a water offset credit. So what the city will do is it will apply that credit to its replenishment obligations when it pumps groundwater. It's contemplated that the city will continue to provide the majority of its water for the next, I'd say, 5 to 10 years as groundwater. We're starting to look at plans to bring in our surface water components, but we're developing water supplies to the north that are a lower cost for us from a treatment standpoint. They're higher quality, like the Adamant supplies. And what the master plan that we've just recently completed highlights is the need to bring in transmission pipelines. So that's another thing that's contemplated in the agreement, is that they'll fund the physical transmission of the wet water, but then through our memberships they'll be able to generate the credits that we'll need to ultimately offset their replenishment obligation.
All this will come out in the study, though, right?
And we're actively negotiating the development agreement as we speak, yes.
All right.
It's a long-winded answer, I apologize.
I guess I didn't know you got water rights from the CAGRD. You got water, but not the water rights. You're saying you get the right itself.
Yes, the CAGRD is an entity that we can use to replenish, that we can generate. We can either do that through a financial arrangement where we just pay money for a replenishment obligation, but what we can
The right
do
is yours. Is that correct?
Correct.
Okay.
They'll fund it, and the right will be the city's.
All right. Okay, further comments? Okay, then, I have a motion and a second. Could I have all those in favor signify by stating aye.
Aye.
Opposed? The ayes have it, 7-0. Now we'll move to consider approving potential changes to the city's rural development standards, and Joe Schmitz.
Mr. Mayor and Council, good evening. This item is one that we've visited before, but we're going to visit it again tonight. By way of history, the Sonoran Valley was annexed back in 2007, and since that time, we've processed several requests for permits on existing lots or parcels, primarily south of 238. And the city standards for new construction or additions are fairly strict. And during this process, we've found that there was a need to take a look at the standards as they relate to this particular area. And staff had come forward back in February of this year with some recommended changes. And at that time, the council said, well, let's take another look at this and get some additional citizen input. So we formed what was called an ad hoc committee to review the standards. The committee members, kind of came in there a little slower that time, had Councilmember Cavalier, Councilmember Osborne, Councilmember Lord, Commissioner Gelzer from the Planning and Zoning Commission, Commissioner DeBrokert from the Planning and Zoning Commission, Tim Keenan for Montage Holdings, Derek Jacobson, who is an owner, mobile resident, Kevin Atterbury, who also is an owner, mobile resident, and toward the end, we got participation also from Tina and Paul Perullo, who are also owners and mobile residents. And obviously, besides the council members, there are several of the committee members here tonight. Kevin Atterbury's here, and we've got Chairman Gelzer, and Mr. Keenan was here.
He couldn't stay. He couldn't stay.
Yeah, I don't blame him, but
He had another meeting.
I'd like to tell you it's going to be a real exciting presentation, but I'd be lying, so. Moving along, one of the things we wanted to make clear from the get-go is that all of the existing uses are considered legal nonconforming and they can continue. New development or subdivisions where people are dividing property, they'll have to meet the current city standards. So this primarily applies to single lot development, people who had already had parcels that they intended to use when they were in the county and then were subsequently brought into the city. Most of the changes being considered are for a relatively small portion of the Sonoran Valley, but as we went through the process, we found some areas in the code that actually could apply citywide that we felt like should be looked at. And one of the things I want to emphasize tonight is this is really a request for policy direction. It's the decisions that you make tonight won't make things change overnight. They won't change tonight for sure, and they'd have to go. Many of the recommendations would have to be changes to city codes or ordinances. They have to go through a whole set of public process, public hearings, and so you'd have another opportunity to review the matter more in depth and make the decisions that you would want to make. And you're not bound by the recommendations that are made tonight. The only thing that would occur is we'd like to get a feel from the council if they're worth pursuing. If they're not worth pursuing in your mind, then we'd rather not and spend our time working on other things. So that's the whole idea tonight. As I mentioned, the area is predominantly the area in the vicinity of Mobile and predominantly south of 238. And what we did with the committee, this is intentionally blank for the moment, what we did with the committee is we met 6 different occasions, reviewed 12 issue areas, and that's what I'm going to go over with you right now is the 12 issue areas that we reviewed. They were summarized in Attachment 1 to the COAC, so you had more detail there, but I'm going to go just over them generally fairly quickly. And then we had one public meeting in Mobile on June 14th that was moderately attended. We had meetings there that were more attended, and also some less. So it was about moderate, but received really good input from the folks that attended. So the first item that we looked at was legal access. The current code is that a property owner to get a building permit has to have legal access for a new home. The proposed change is that if legal access we would still require them to show us legal access if they can, but in certain instances, we may accept something less. If the access is not fully documented, we may accept evidence of a prescriptive use where you can tell that it's been there for a long time. So that would be a change in policy. With respect to roadway improvements on the width, our current code is the roadway must be paved, it must be 33 feet wide with curb and gutter, sidewalks, the whole 9 yards. And obviously in the mobile area, those types of improvements aren't present. So the proposed change would be to allow development to continue, but with improvements that would be made to the greatest extent possible to provide at least 20 feet in width. In most instances, that's fairly easily achievable, so that I don't think it's a burden. And we would also, of course, want to make sure that it's PM10 compliant.
Are you wanting to take questions during your presentation here?
Oh, that's fine.
That's the best way. Can I interject on this one? So if I'm a landowner or a property owner of an acre at the end of a street, there's 20 homes I've got to pass to get to what is now an empty piece of property, and I'm going to construct my 3,000 square foot dream home, and down in that area, I've been deeded that piece of land. Are we going to then, and that road is not PM10 compliant, and that road is not up to current standards, are we going to make that last in property owner bring that road up to compliance?
Mayor
For the
Kavanaugh,
benefit of the other 20 people that are along there?
Mayor Kavanaugh, Vice Mayor Antoniak, obviously the current requirement is that the road be paved, so what we're talking about is doing something less than the current requirement, but finding some middle ground that we can still maintain consistency with the principles of PM10. There's a variety of ways that it can happen. There's a possibility that we could encourage the property owners to get together to do something jointly, or
But the other 19 other property owners aren't going to join me in an expense that they didn't have yesterday because I want to build a home.
Well, that's true.
See what I'm saying?
This would really occur in instances where it's a private roadway as opposed to where it's a public roadway. Because public roadways, we're basically going to be stuck with those, the ones that we're taking care of.
So if it's a public street currently in that environment, we have some public streets that
There are some,
just
that's correct.
graded. The county goes down and grade. Now we're responsible, or we're contracting with the county to grade those. We're going to bring those up to PM10 requirements at some point in the distant future?
At some point in the future, yes.
Okay. All right.
Moving right along, with respect to surfacing, this again is along the same lines. The improvements we would want them to get brought up to code as much as possible, be PM10 compliant, in no case compromise public safety. Also, we would want to require the owner to dedicate right-of-way for the roadway if it's a roadway that we want to be public. Maintain it if it's a private roadway. We aren't interested in assuming responsibility for private roadways. And then also require that they agree to participate in a future paving district. So these would be things that we are going to entertain as requirements for getting the building permit. With respect to design standards, we have minimum radius and maximum grade requirements. Once again, if the roadway doesn't meet those, we would try to have the property owner bring them up to standard as much as possible. In most cases, the radii and grade are not an issue in this particular area. Fire protection requirements. The current code is that sprinklers are required for homes over 5,000 square feet. Sprinklers are required for homes over 3,600 square feet if access and fire protection available is substandard. And then no sprinklers are required for homes under 3,600 square feet regardless. Proposed change at this point is none, although we do have some reason to believe that a sprinkler requirement may be part of the 2009 IFC code revision cycle, in which case the city would have an opportunity to reconsider that in connection with that code cycle. Solid waste collection, the current code is you're required to pay for service kind of regardless. whether you choose to use it or not, or if it's available to you. Initially, that seemed to be an issue. There were some property owners who were concerned about the impact the trucks would have on their private roadways, and our service provider was requiring hold harmless agreements to be signed. There were a few folks that were holding out, but everybody's kind of come around now, and this no longer appears to be an issue. There were also some things done with respect to bulk, where a container is placed at the Mobile Elementary School. The hours and the placement number of containers was modified, and so that also seemed to be working out okay. On water supply, the current code says that new homes must have a potable water supply. That's kind of obvious. Proposed change, we would limit the use of hauled water upon a demonstration only if a well is not feasible on a piece of property. There's currently really not a provision in the code that would preclude the use of hauled water. We would also require new homes to have a stub out in a logical location that would facilitate future connection. That'd be something you'd install when you construct the house, and that way it'd be in a location that facilitate the connection to the main line when the main line came by.
What is the criteria for feasibility of a well? Is it depth?
It would have to be based on information provided by a licensed well drilling operation that is familiar with the area.
Everybody can have a well, you know.
Well,
depends on how deep. Is that what we're talking about? That if it's over 300 feet, you don't have to do it, or
if it's prohibitively expensive, would be one of the criteria.
which is what?
More than the normal well in the area. I don't have that figure off the top of my head, and obviously that's an item we'll be refining. We would ask the owner of a new well to agree not to object to new city wells that are intended to serve the property. We have to get a permit just like everybody else when we drill a well. We have to assess impacts within a certain radius, and we would ask that owners of wells, new wells, not object to our applications, particularly if they're intended to serve the property where the existing well is. And then the recommendation would be that the use of any well would stop when a property owner chooses to connect to the city system.
I'm sorry, Joe. I know this was brought up during our discussions. Most of the items that are in this are for Mobile, but this does touch on, say, Wade Acres. I know there was a couple of issues that I just wanted to clarify that Wade Acres, because some homeowners do have wells there. And I don't know if Vanderbilt Farms has wells, but just want to make sure that those properties have been notified of this, or are they grandfathered in and won't be?
Mayor Kavanaugh, Councilmember Osborne, it's kind of a yes to both. One of the public hearings that we conducted, we notified Wade Acres and Vanderbilt Farms, and we had a few phone calls, but we didn't have a lot of participation. But secondly, Wade Acres had kind of a special deal when they first got the water lines extended, and they would be grandfathered and continue to operate under that prior agreement.
Okay.
They would hook up to our sewer line if it came through.
Well, in this particular instance, we're talking about water,
Yeah.
and what would happen with their well if they choose to connect to the system. And the recommendation is that if you and initially, we had even considered requiring connection once the water line was available and discontinuance of the well. That recommendation evolved over time to a point where, is if the owner elects to connect to the water line when it becomes available, then the use of the well must stop. But it's the owner's choice to connect or not to connect at that point. On the wastewater side, the current home is that if you have a septic system, you are required to abandon that system or discontinue use of that system within 1 year after a public sewer line comes past your property. And one of the changes that we talked about is defining what available is, and that would be, say, within 100 feet of the property. New homes would have to have a stub out. If they have a septic system, they'd have to have a stub out for future connection to a public sewer, much in the way we were talking about the water. And the proposed change here would be to allow existing systems to continue for 5 years after the public sewer becomes available. or until the existing system fails, in which connection would be required immediately, or upon change in ownership of property, whichever of those three events would occur first. So,
Rationale for that one. Why wait 5 years?
Give you a chance.
I believe, Mr. Mayor, I believe the rationale was that 1 year may be too short a time, particularly if somebody had just put a system in not too long ago, that they haven't fully had a chance to amortize the cost that they had invested in that system, and that 5 years seemed to be a more reasonable period of time.
That is one point they really protested on. They wanted that time frame because of the cost.
Yeah, it's a lot cheaper for them, frankly, once they've got it installed.
Yeah, it was the installation that was the cost factor to it.
And they have to take their, once they hook up to the public sewer line, it's their responsibility to take out their old septic tank.
Decommission.
Yeah, Mr. Mayor, Councilman Cavalier, it's their responsibility at that point to essentially decommission or take this system out of service, and there are guidelines that they have to file when they do that. It's not necessarily remove the tank, but I think they have to fill the tank.
With ABC. Or something.
All right, the next one is manufactured homes. And this has been primarily directed at the Sonoran Valley. Currently, manufactured homes are not allowed in either the AU or AG districts, which is the zoning predominantly in the Sonoran Valley area. One of the proposed changes is that we would create an overlay zone in certain areas, particularly south of State Road 238, where there are a number of manufactured homes already in place, to allow manufactured homes, but subject to new design guidelines that we would develop for them, so that they would be essentially a cut above the existing development there.
In that area, how much property is available to manufactured homes, Joe? Do you have any idea?
I heard my name. We did a little look at that. If I could get Elmo, please. Thank you. This is south of 238. What we would do is create an overlay zone and identify specific areas where there already are manufactured homes and there are vacant lots that might infill. And we would try to identify those and then just create an overlay zone district just for those particular areas. A rough beginning of that is the areas outlined in red here. And as you can see, it's not a very extensive area, and this by no means is set in concrete. We would have to develop the overlay zone. We'd have to go through public hearings and a process of actually placing it on the property. And all the landowners, both within and outside, within the area and within 500 feet, would be notified and have the opportunity to provide input as to what they thought about the structure of the zone.
So all those red dots up there represent manufactured homes?
They represent existing homes, most of which are manufactured. There's a few site-built homes.
Are we going to require certain standards for manufactured homes?
Yeah, Mr. Mayor, Councilman Souza, it is our intent to develop design standards specifically directed at manufactured homes because there are some that are nice and there are some that are nicer. I put it diplomatically. And we obviously are interested in the ones that are nicer than not. And but at the same token, they have difficulty meeting our current design standards because when they're manufactured at the factory, once they come out of the factory, you're not supposed to do any modifications to the home unless you get a permit through the state or through the agency that authorized that supervised the construction of the manufactured home. So we want to get these standards in place based on current construction practices that I would identify what would be acceptable and what would not be acceptable.
Vice Mayor?
Just to illustrate my question earlier, and I'm still struggling with this, if you take and go to the far southeast corner of that major area down there that's got the home development, say south of Kinney Road, down in that section that goes east. You take your pen, move it.
This one?
No, right, yeah, down a little bit. See these subdivided lots right down below your pen right there? There's like 5 acre, maybe.
Right here?
Yeah, so I'm a home, I've owned that 5 acre lot now for 5 years out in that community, and I've planned on building this home. I'm still struggling with this example. Are we going to ask that individual that builds a house down there to construct the 2 lane miles back up to Highway 238 to PM10 requirements on the roadway infrastructure?
Mayor Kavanaugh, Vice Mayor Antoniak, the current requirement, and I guess I'd have to ask you first to clarify the question, is there a road there now, or is there no road there now?
I think when I had
In your example,
Councilmember Lord and Councilmember Holland in the vehicle with me when we went down there for a community event, we drove down in there. If you remember, I don't know that those roads are PM10. They're just ABC. I mean, it's just
Except we have no
aggregate.
choice. They have to be PM10 compliance.
Yeah, no, I know.
I mean,
But
there isn't any choice anymore.
How we implement this is going to be a challenge. I wouldn't want to stand here and kid you that it's going to be easy, but we're also looking at situations where there may be the property and there's no road whatsoever. What level of improvement should be provided for that lot in order to reach another improved road? So these are the standards that we're going to have to struggle with. The recommendation is that we should come up with something different than simply just requiring pavement, because that would be cost prohibitive for somebody to pave from their home all the way out to that road. So we're looking for something in between.
it seems to me that just an idea that's going around in my head, and whether management's office, you've thought about this or not, but I remember early on in '03 when I sat on council, we paved a road way down south that made absolutely no sense in paving except for the fact that it was a PM10. You know what I'm talking. I see the look on Cato's face. He knows exactly the road I'm talking about. And it was PM10 money that went towards that road. We ought to be looking for every grant opportunity and every source of money. We ought to be having Matt Hansen look for air quality.
He is.
Is he? Okay.
This is going to be probably MAG money anyway.
I would assume this is MAG money. Okay. We do. Okay. All right, so I'm barking up a tree you guys already have barked up.
Let me try to understand this. Go ahead.
I'm struggling with this. If somebody's owned a piece of land down there, I mean, I'm struggling with the right they had yesterday versus the right they're going to have as part of the annexation. And anyway, I'm sure it'll be a continuing dialogue that you all are having.
Exactly. The right was at risk already, though, with the PM10 requirements that were put into place, not only by the city, but by the county.
I was going to say, would the county have said, no, you can't build unless you put in a PM10
Well,
road?
I'm not sure exactly what the county has come up with yet for the county requirement in response to the new PM10 requirements. But what I'm saying is that property owner would have to contend with it either way.
Gary and I think alike. We ought to put an airstrip down there.
And I want to reemphasize that the current requirement is to pave it. So we're talking about relaxing the requirement, but trying to find something that would work for PM10.
Might I answer that question? PM10?
I'd like that.
Okay.
Unless you
It'll
want
be
to-
a continuing dialogue, I'm sure.
We'll open it up to the question. Identify a section there for me.
That's the section there.
Each one of those.
Each square, yeah.
No,
Oops, I guess you can't really see
he's
my...
got, his
That's-
hand is off the, there you go.
That's the section. Oh my God! Thank God. Okay. So in other words, it's about we're talking about a total of a section or section and a half.
Roughly, yes.
Okay. All right. And is this the same land that we're making the changes in the land usage also, or is it more than that? I know it's weight acres maybe too, but where we're given waivers for the use of the land, for the septic, the well, is this the same limitation?
No, Mr. Mayor, the overlay zone would apply predominantly to the manufactured home aspect.
Okay, then tell me what area are we allowing waivers for land use, the wells, the septics, and that sort of thing?
They would basically be every district, everywhere that's zoned AU or AG, which is a fairly large area within Goodyear.
Anywhere in Goodyear.
Wow.
That's not
That's a bigger issue.
It's not going to happen.
Pardon me?
It won't happen.
It won't happen. It is. We're being asked to
No,
move
I
it
mean, other
forward.
than this.
It wouldn't happen other than this.
I think what Councilman Cavalier is referring to, there's a lot of areas that are zoned AU, AG that are, particularly in the northern part of Goodyear, that are continuing to be used as farms, and they haven't been parcelized. It's where this is likely to happen is where you have these smaller parcels created. In this case, I mean, this is an example of parcelization, well, just as well as this is here.
But it's two.
But when they're in larger tracts, we're not promoting this for the larger tracts to be subdivided into that. It's only for those smaller existing parcels.
But why couldn't a developer go in and buy a section and do that?
Well, if they're going to buy a section and develop it as a subdivision, it would still be subject to our current rules, the way we would structure it.
Because they would have to go through all the subdivision requirements. and
Right,
the
because they're
requirements
subdividing
and
property,
everything else.
they're creating parcels. That's
If
what
they
you
came
do.
in and bought an already subdivided area that hadn't had homes on it, would there be any limitation?
That's a tougher question.
There's a few of those down there.
Uh,
I mean, you just pointed at one, right? Or is that one has homes on it?
Well, this one fortunately is Montage, so
Oh, okay, all right.
so it's not really an issue, but it's mostly these, if you want to refer to them as mom and pop or wildcat subdivisions, where somebody took a piece of property and under the state law and county regulations, you can divide it a couple, 3, 4 times without being considered a subdivision. So those are the ones that are really mostly affected by this, by the changes. The larger tracts.
And are we promoting that? These small,
No, we're not promoting it within the city limits, no.
are we permitting it with this change?
No, we would not be permitting it, because our subdivision rules would still apply. And everything we've talked about tonight, they didn't appear on the slide, but it appears in the standards that were in Attachment 1, does not apply to property being subdivided. Our current regulations would continue to apply. So it's not encouraging it.
Subdivided, it would be new building permit on an already pre-owned piece of land.
Right.
So if somebody took that section that's roughly 80 acres or so right there in the middle, south of Kinney Road, and wanted to subdivide that into 100 homes, that would then have to fall under
Have to
compliance
meet
of
all
our
the
subdivision
requirements.
rules. And we would, I mean, that to me is the case, yeah, you build a road, no
Right.
question. It's that unique outlying case that I struggle with.
Shall I move on? Okay. Can I get the PowerPoint back, please? Thank you. In the overlay zone, we would also make it clear that existing manufactured homes that are outside the overlay zone could not be modified or replaced. Existing manufactured homes in the overlay zone could be replaced or modified, provided they met the new design standards. And existing mobile homes, and a mobile home is different than a manufactured home, cannot be modified or replaced. So I think we're still moving in the direction of a higher standard and a higher level of development. Okay, the design guidelines themselves, as I mentioned before, we have design guidelines for site-built homes, but none for manufactured homes. We would want to create a specific set of design guidelines that are specifically for manufactured homes. Off-street parking, our current code says that you have to have a driveway and parking for single-family homes that must be pavement or concrete. The parking must be within a garage. The proposed change would be to allow unpaved driveways in the AG district and in the AU district whether they connect to an unpaved roadway. All unpaved driveways still would have to be PM10 compliant, and then allow use of carports for required parking in those districts. And this is just the agricultural districts. The keeping of animals, the current code says you can have horses and livestock in the AG district, which is the district that has a 10-acre minimum lot size. with no limits on the number of animals. There are some setback and some standards that have to be met. Horses are allowed in the AU district with no limits, but livestock require a use permit. The proposed changes on the keeping of animals include continuing to allow horses and livestock in the AG the way it is now. Continue to allow horses in the AU district and allow livestock, but limit it to 3 per acre and subject to setbacks. And allow certain types of small livestock, like ducks, chickens, in an AU district, but limit to 10 per acre and subject to setbacks. And then if you combine them, the combined number would have to not exceed the maximums allowed for the animals. So you'd have to give up a horse if you're going to have some of the smaller ones, or vice versa.
Joe, could we keep up with that from a enforcement? I mean, how do you enforce something like that?
Neighbor complaints.
Mr. Mayor,
Code compliance assured us that they would be checking into this, and the county code, also the county. Didn't she say there was a county that...
The county code is basically that you're not allowed to have animals for commercial operations. So if you have a number of animals, if it's an acre lot and it's a family living there, and if they have 10 horses, obviously that's fairly obvious that it's not for personal use, that it's just something else is going on, in which case then they would enforce it as a commercial operation. But if you have a specific number, I think that's actually easier to determine than trying to make the determination if it's commercial, non-commercial.
So we would have to be vigilant about checking on these properties.
We would, but I think as a practical matter, I mean, it's like a lot of things that we experience.
Yeah.
We respond on a complaint basis to ones that are issues. But if we could see it ourselves, then we could also move on it. Continuing on that item, the maximum number of animals could be exceeded for what's termed a supervised agricultural experience project, which is basically like 4-H or FFA with an issuance of an administrative permit. If you don't exceed the limit, you can just have them anyway. But if it would exceed the limit, we would still consider allowing it with the issuance of an administrative permit. Currently in the AU district, if you wanted to have a livestock project, you'd have to get a special use permit, and it costs $2,400 and involves a hearing. And so the committee felt that that was too onerous and that something else should be created to allow it. And then a new requirement would be that horses would be provided with shelter of some shade or shelter of some sort. So that concludes the series of recommendations. In closing, I think going through the process with the committee was helpful. It was particularly helpful with the input that we got from the Mobile residents. And so, I think we came up with some things, or changed some things that would made it more palatable and didn't hurt the city in any particular way. So, I stand for any further questions or
Any comments from the public? Any comments from the public?
I have a question on the water.
Would you come up to the microphone, please?
I noticed that when it said that if you have an existing well and you opted to go with the city water, that you couldn't use your well anymore. If in these people's case they had an acre of land that they were irrigating, would they still be able to use the well water as irrigation and the city water as domestic use?
Good question.
Very good question.
the answer is the recommendation that was made was that it would not be allowed to be continued, that it would be, since it's at the owner's option to tie on or not tie on, that if they tie on, they would be required to discontinue use of the well, since they'd be receiving water from the city supply.
Wouldn't that be really detrimental to our country?
I'm sorry, I didn't hear the
Wouldn't it
question.
be detrimental to conservation?
Well, I think
What we're proposing today, conserve water?
there's a number of concerns. Obviously, one is meeting our conservation goals that we're going to be that we have to set as providing the assured water supply. There's always the threat if a well isn't taken care of properly and is not used, there's always the opportunity potentially for cross-contamination because we'd be potentially pulling water from the same aquifer source that the other well is operating in. So there's.
But you're going to let him stay in the well if he wants.
Yeah, right.
So.
But if they stay on it and it's actively being used, it's less likely to have that cross-contamination issue than if they have the city water and then maybe we're going to use it, not use it.
So we allow people in Vanderbilt Farms to have a separate water source for irrigation. In fact, that's one of the selling points of Vanderbilt Farms.
And how big is Vanderbilt Farms compared to Mobile?
1 acre lot.
I mean, the total.
It's
Total
bigger.
total
It's at
acreage.
least, it's about the same size. I'd say about a section maybe. Yeah, it's about a section, isn't it?
Okay.
But Vanderbilt's already grandfathered in.
Mayor, there is one thing down there. We didn't see any agriculture. There isn't any irrigated fields out there, is there?
For the most part, there's not a lot of farming, irrigated farming occurring, although I believe the gentleman was referring to the fact that if you have an acre, obviously,
If you could.
If you could, you'd probably prefer to keep your well water to water the acre. So,
I thought they were concerned with just water for livestock.
there were some. There was at least one individual that
Yeah, because
raised
that's
that
what I
question.
thought they were talking about was.
The way we've structured it, at least to this point, and once again, that would require a change to the city code, and it's not going to happen after tonight's meeting immediately. But we also considered putting in a provision for a waiver of the requirement upon a showing of some need for continuing the use.
On a
So-
case-by-case basis.
On a case-by-case
is what we talked
basis.
about.
Right.
Could I add something else, Mayor? if I may?
Yes. Yeah, open for council now?
Is it? Open for council. This isn't the cure-all for all of that, and I think eventually we'll have to make some changes. And I think that this will come with time, and I think this is a first shot at this, and I think we did the best we could with what we've got. And I think that when these concerns come up, as they come up, I think adjustments can be made as we go down the road. And I would hope that your department would feel that that's, okay, thank you.
Vice Mayor?
Is the irrigation in Vanderbilt Farms, is that well or is that RID? It's
That's
RID.
RID, yeah.
So it's, okay, so it's got a
That's
regulatory,
not well.
yeah, so it's not well. So wells and pardon the term, in wildcat subdivisions are a far different issue than RID, who's got other governing bodies that they've got to answer to. But there is a part of me that says it's counterintuitive for us to treat this gentleman's example, treat all the water that then is going and being irrigated on 1 acre of land when they may have a well that could irrigate that acre or 2 or 3 or 4 or 5. It seems, I mean, from a water conservation standpoint, I guess I can understand some point, but maybe there's some provision that we could say, if you are to show that the well is not cross-contaminating, or there's, there are certain, you got to help me out here, Sean. I don't know what the regulations are for those. Isn't it less than those less than 35 gallons per minute? That number's sticking out in my head for some reason. But less than 35 GPM are sort of unregulated, and all of a sudden you get 100 of those in one area, and you're tapping a lot of water.
You're not going to have that.
Mayor, Vice Mayor, the provision you're talking about is exempt or non-exempt wells, and there's sampling frequency and the amount of water that they produce. Our biggest concern, and again, as Joe mentioned, we could look at it on a case-by-case basis, but our biggest concern is going to be cross-connection and a potential cross-contamination. They would most likely be pulling from the same aquifer. The city will treat its water to the regulatory standards that are required, whereas a private well may or may not be treated to those standards. And if a cross-connection occurs, and there's no way for the city to monitor that because the city's responsible from a water supply standpoint from the meter back into the street. But from a water quality standpoint, our requirements are to the last free-flowing tap within the home. So we're responsible for the quality that our citizens drink.
So your concern is that homeowner puts a water meter in, then connects that old water source to the.
There'd be no way for us to
new
monitor.
system.
If there was an on-site
you would
well
wait it out.
and they wanted to continue to use that well for livestock watering or landscape irrigation, the potential exists that, the owner could cross-connect the two systems, and then if the right conditions occur, that water could flow into the city system, and if there's an issue with high arsenic or nitrates or bacteria, then that issue would then that problem would be passed.
If somebody could there be a requirement for greater backflow devices or something that would prevent that cross contamination from occurring this side of the water meter?
The only thing that would for that type of cross connection is there's no recommended device because it's not a recommended practice. But short of an air gap where you physically take the potable water and put it into a tank and there's a physical separation between the two water supplies, so there could never be a backflow condition. Any type of device could fail over time. And again, that becomes another regulatory or a compliance issue where the city would have to monitor the status of the device. It's a complicated situation. I think case by case, if there was a 5-acre parcel of land in the back 3 acres, they wanted to do something, the city could look at that. But our concern is, and it has to be, we're the potable water providers for the city and all of its citizens. And cross-connection is just it's a dangerous game. Sounds a little over dramatic.
I was going to say, okay.
Our responsibility is the quality.
Sorry.
Understood.
Yeah. Okay.
Thank you.
Seems like there ought to be a workaround in some way to be rational. I mean, we can't forget about being rational in this process, some way, shape, or form. So.
But that's why we left case by case. That's why we left the door open and closed doors.
I think Frank actually said it very well, that this is our,
Yeah, no, it's the first
you could say our first stab at it, but this is the first time the city's had to
We'll be
deal
making
with this.
changes.
Yeah, that's right.
Was the, Mr. Director? Sure. Was the committee in full agreement with the recommendation?
And the citizens that were there. They
Yeah,
were there.
citizens were too.
They were there, they were there for it. In fact, we changed some things that, what was the name of the couple? I forgot already. Is that terrible? Tina and Tim Paulo. Carallo?
Well, there were 3.
Yeah, they came, and later, they came at a later meeting. They weren't at the first 3 meetings we had, and they had a lot of constructive input, and we did change some things. And we were open when we went down to Mobile and talked to everybody, invited the citizens in. We were really open to their suggestions, and we weren't there to change their lifestyle 100%. We were just trying to blend the annexation in to their present lifestyles, and we were.
Well, I go for the recommendations of the committee, the residents that were involved.
Okay, let's ask further comments from the public. Seeing none, could I have a motion to approve the potential changes to the city's rural development standards?
So moved.
Second.
I have a motion from Councilmember Lord, second from Councilmember Souza. Again, it's open for discussion. Further discussion? All those in favor signify by stating aye.
Aye.
Passes 7-0. We'll now move to comments on current events from council. Any current events you wish to speak about?
Well, nothing is current after we've been on vacation, but
There is.
I'll bring it up anyway. I mentioned it to some of to the mayor and our staff person that supports the council that I got an opportunity to do the light rail, and I took the tour and with our model train club, and Gary was along also, and we not only took the tour, we got a chance to ride on the light rail. And I'm telling you, that was very exciting, and we definitely ought to try to do something with that parish, and I think the council would really appreciate the experience, and also hear the latest information on it. We got some that kind of came out tonight, but also the fact that they're going to try to run the light rail to 99th Avenue. So I think that's something that we definitely ought to be thinking about. Thank you.
Okay. And, yeah, we took the ADOT tour to see the bridges and see how they're constructed. Mayor of Avondale and Representative Nelson was with us, and we had quite a tour. ADOT gave us all the details of how they set the rebar and construction and why the bridges are closed and some of the streets are closed and then they're open and then are closed again. But it's because they can't do all of the work, all for every bridge completely from the beginning to the end, because there's not enough room to store the materials in place so that they could. They did it with one, and that was a straight parkway. They did all of east-west. They did both east-west and did it all in one shot. So now that bridge is totally done, or that overpass. So the others will close periodically to put either the west or the east section of that bridge in. So it's coming along very well, but it was very exciting to watch that. And I'll tell you one thing, I do not want to go on construction and bend rebar to put a bridge together.
In July.
Especially in July, right. Thank you.
Councilmember Souza.
Thank you. On a personal note, I would like to thank the council for the Get Well cards. I talk about your vacation. I didn't have a very good vacation. And also the employees who sent me cards and telephone messages. I felt so good about that. The flowers, beautiful. Thank you again.
City Manager, current events?
Yes, Mr. Mayor, members of the council. The first item I have this evening, I'm very pleased to introduce Patty Evans, the newest member of our staff. Patty comes to us as the new Community Services Director. I hope she's met all of you. If not, take an opportunity to meet her. But welcome, Patty. It's good to have you here. Secondly, I'd like Jim Nichols to make a brief presentation to another member of our staff.
Thank you. Mayor and Council, I'd like to ask if Connie Stepnitz could join me up here. For those who aren't aware, and I'm sure everyone is, for the past year and a half, Connie had served as the acting or interim Community Services Director. This has been after Jareen Watson moved on to another position at some point. And it was a very lengthy time that Connie put in to that position. She not only helped keep the department moving forward, but really helped them thrive and succeed. She worked on MAG committees. She worked on a number of different community services initiatives. And she also continued serving as my management assistant during that whole period. So I really appreciate all the work and effort and time she put in during that period as the interim director. Wanted to offer a plaque from the city, and I just wanted to read it if I could. It's an Outstanding Service Award presented to Connie Stepnitz in appreciation of outstanding service as the acting Community Services Director, December 2006 to August 2008. So this is our way of saying thank you very much to Connie.
Mr. Mayor, if you would please.
I'm sorry.
You weren't going to let it go.
No, I wasn't going to let it by.
On two occasions, I had the disadvantage of losing two very highly qualified assistants very abruptly with very little notice. And on both those occasions, I went and sought the assistance of one of our finest leaders, Mark Brown, and he said, "Take Susan Petty, please. Take Susan Petty." And so I followed Mark's advice, and Mark was right. Susan, would you come forward? I think I've been praising Susan for quite a while now, and she's probably tired of listening to me.
Never.
Never? But I want to thank you because when I needed help, you were always there. a very loyal and trustworthy human being, so thank you, Mitch.
Thank you, Mr. Mayor. Next, I want to briefly inform the City Council about the status of the Performing Arts Center and what we are doing with regards to that. As I had promised you on June 6th, or June 9th, excuse me, when the City Council voted to reject the RFP to seek the Performing Arts Center, I told you that I would bring back a recommendation to you at the time that you came back from vacation. At that time, you voted unanimously, 6-0, with Frank abstaining, to reject that, the RFP. What we have done is we've worked with Langford and Associates. They have, as you know from earlier this evening, they've been selected for the excuse me, the P3 process to build the city center. We worked with them to determine are they interested in pursuing a performing arts center, and they are. However, they first need a market study to make any necessary considerations as to what is the market out there for the size, etc. So I have authorized a market study to be conducted on behalf of the Performing Arts Center. It will cost in the neighborhood of $45,000 to $65,000, which we do have in the budget, and so we are pursuing that with the preparation of an RFP right now, and we will be going out with that in the next few weeks. Once the city attorney has determined that the Performing Arts Center could be wrapped into the P3 project, if that is determined to be the way to proceed. We have gone through the procurement process already for that, so it is a possibility. If, based upon the market study findings, staff will work with the Langford team at that time to see if it will fit into the project or not. If it doesn't, we will then prepare a recommendation to you to go out with the another RFP for the Civic Center or for the City Center project. As you saw earlier this evening, we have 5 acres set aside in the project area for the future Performing Arts Center, and so that is all being taken care of. So the next step is to get the market study done. That will be completed by October of the end of October this year, and so we're proceeding on that basis. We are doing on the boards and commissions, we are doing a yellow paper for the council next week. And we have 4 boards and commissions that we're looking at right now: the Higher Education, the Centennial, the Youth Commission, and the Sister City. The Higher Education is one that you'll see in the yellow paper. Both universities are asking and recommending that we put off for a while. They feel that it's premature to appoint such a committee, but you'll get that in the yellow paper next week. The Youth Commission, we had promised that once school came back into session, we would get that going, and so now we're going with that. And the Sister City and the Centennial are 2 that we will also be looking at, but you will get that in next week's packet.
Is Sister City going?
Also, I just remind you that I sent out last week a work session survey, and I encourage you all to fill that out. For example, tonight 1 or 2 things came up. One was the options or discussion of the options of how to pay for the impact fees. That could be a topic for a work session. Basically, for the benefit of the public, I asked the council to take a look at the work sessions to try to provide more meat for the discussions that take place during the work sessions. That we list those items that you are interested in pursuing in work sessions, and then we can schedule them out in a 6-month time frame. And then we can also try a little better. Tonight, for example, I wish we had more time on the City Center, because there was a lot of discussion there, and I think it could have taken a lot longer. So we are working on that, but if you want to get ideas to us, please, I'm collecting those, and I will report back to you what we find. Another one that came up in the last few days is the criteria, develop criteria for when is an incentive a good idea and when is an incentive not a good idea. And what the criteria is for granting incentives. Is it jobs? Is it retail? Is it things like that? And so that's one area that I think would be a healthy discussion for the city council to have. Right now, we don't have any policy. We don't have anything in writing on what we take a look at. We did have an ordinance that expired in 2006, I think it was, setting forth some criteria, but that is expired now. So we will take a look at that and be suggesting some things to the council for the future. Then some things for follow-up from tonight's meeting. We have an architectural overlay for City Center. We'll be taking a look at that to raise the bar for design of buildings, and we'll also look at the gateway overlay to work with that. The siting of the library and the relationship to the universities, and the size of the library and its relationship to the accreditation. We will certainly take a look at that. What is the distance to the high school vis-a-vis alcohol in a restaurant in City Center? We will take a look at that. Smart use of water, the mayor mentioned, both from an irrigation standpoint at City Center, but also from what I refer to as a recreational, ponds or whatever. We'll take a look at that, certainly. Then water meters from three sources. Mr. Sousa's question, we will provide an answer to that, and we will also provide that publicly. To certainly take care of Gary's suggestion. And then why pay GPEC? We will respond to that for Joanne's benefit, for the council's benefit. That is the annual dues that we pay them. But the question has come up in the recent past as to what do we get for GPEC, and we are preparing an answer for that. So that will be something that's discussed in the future. Excuse me. Mary Greener and her items for follow-up, we will aggressively pursue those. And then finally, a moratorium on impact fees. Is there different options that can be introduced? Is it possible? What Rob was talking about, what if, is one option only paying one half up front and then one half when it's done? So we will look at options and bring that back to the council for your work on that.
John, just to clarify, I can talk to you offline. I wasn't saying a moratorium per se. I don't want any mistake
That is
to get
one
out
option,
there.
however.
That is one option. I know there are some cities that have done that, but without further.
And we can't do that legally. I don't know if Rourke's.
No, without debating
getting
the issue, and I don't want to get into a long discussion because we don't have it on the agenda. But
I
I'm happy
understand
to
that,
take it
though. Thank
offline
you.
and talk about it more.
That's all I have right now, Mr. Mayor.
Okay, thank you. Inquiries of council to staff. Councilmember Osborne.
Since we've been gone a month, I have a little homework. I would like to see the city's marketing and advertising plan for the ballpark and for attracting tournaments and events. I'd also like to see what, I don't know who's exactly in charge of that, if it's going to be Paula's department or Nathan Torres' department, I'm not sure, but what budget they've been given for marketing, what's the money that they've been allowed to use. That's one thing. We were discussing the City Hall tonight, and happily so, that if we are in City Hall in 2010 or the latter of 2010, what will be the use of City Hall now? I'd love to see if it could be the Public Safety Administration building. Rob brought up the impact fee phasing situation, and there's something that when he stated that occurred to me that I've heard in the past, that we will take as a city a credit card payment for some of these things, and I don't know if the council is aware that when that occurs, especially if you're talking about, say, a $2 million apartment building, we will get dinged at least 1.75%. That's $35,000 that we are losing because we took a credit card swipe. And I know that that is how business occurs in retail, but I don't know that that's the best way that we do things, and I don't know if there's policy on that. So
Sorry.
That could be really ugly, but it's, that's one thing that could add up quite a bit. And lastly, since the topic came up about the grants for the PM10 issue, there's this street in Vanderbilt Farms that I've been talking about.
We know what street that is.
I'd love to see a grant get help for that. Cato knows exactly what I'm talking about.
Good move.
So, thank you. That was my homework.
Vice Mayor?
I'll pose it in the form of a question and not an agreeing statement. My wife reserved a Ramada over at the park last night and got charged a $2.31 convenience fee. And if we're not charging that same fee on $35,000, we've got a discussion to have. Because that was a $25 reservation at one of our parks. But the inquiry, I forgot what I was going to ask. Oh, it wasn't an inquiry. It's very rare that a city manager gets a compliment in public, and I just want to commend you, and I think the rest of the council would agree, the grace and the professional grace by which you and your staff have handled the situation surrounding the ballpark is second to none. And I just wanted to publicly state thank you for the way in which you and Rourke and Brian and Jim and Regis and everybody else have handled the situation, and Sarah and Nora and Paul. It goes down the line, but the staff as a whole has handled that with an amount of professional grace that is fantastic.
We all thank you very much.
Nicely said.
Okay, next meeting is not next week. Next Monday is Labor Day, correct?
Right.
So we'll meet on the 8th. Okay? Meeting's adjourned.